Thank you very much for your kind welcome and for the opportunity you give me to present some of type of short summary of one chapter of a book I'm writing right now on the status of law in international relations. It is called The Dark Side of Global Governance, Unresolved Issues in Theory and Practice. Globalization is a fact, but not a fact is what we should do about it. Should we go along or resist? These are the usual choices which are given to us. But before we celebrate universality or counsel resistance, we should examine what are the alleged advantages or the downsides of it. For my purposes here today, I'm not so much interested in the particular distributive outcomes of various regimes or best practices, although one wished a more critical assessment of what the benefits, for example, of free trade or convergence regulations are. They are always bantered around, but I see very little studies on that. I'd rather focus on conceptual issues, the nature of the global domain and the exhortation to embed systems of governance in broader global frameworks of social capacity and agency that did not exist previously. This is from my once collaborator, John Ruggie, and the implication is that global governance is a good thing from this angle. I shall go through three issue areas in this talk: collective goods, regulation, and human rights. And I shall look at them through two questions. The argument of demands for new institutions in politics, since politics has largely moved out of the domestic arena and is now taking place in all types of weird places. You look at regulation only and the making of rules. The WTO alone has 35 sites in which norms are being discussed, made, applied, or circumvented. So this then raises the issue, what are the potential new forms of global participation or of accountability? And here, of course, we have immediately some celebratory moves again by cosmopolitans who think through the reform of the UN or some globally legalization and constitutionalization. We will move ahead. But in this context also several new questions need to be raised. First of all, one is the argument that the demand for regimes, the old argument that since there is now this demand, it will be met, and how it will be met, whether it at all will be met, that means having not a clear answer to these questions means that there are different solutions which are not necessarily equivalent or all equally good or equally bad. And we should therefore counteract the functionalist fallacy, which does not become truer even if it's constantly repeated. So we do have choices and we must make choices. It is not simply a question of necessity. There is also the assumption of separability of issues, a so-called naturalization move, and of the proper diagnostic solutions that can be codified ex ante. Because much of the argument for best practices, for example, relies implicitly on the assumption that you can specify ex ante, so to speak, context independently criteria, and which are then applicable and help you problems from bookkeeping to peacekeeping. But this flies in the face of both logic and experience. It raises the issue that global governments might neither be technically efficient, nor effective, nor as benign as it made out to be. Precisely because the various forms also of cooperation between states, markets, and sectors of private society might subvert the actual virtues Let me come to the part of logic. I claim that the inference about the good effect of universal global governance is based on a simple fallacy of composition. Thus, even if we make the assumption and go down that road, that issue areas are independent and can be defined so well and will function if proper regimes are made or put in place, it doesn't seem to follow that governance as a whole will also have the same effect. It might very well be that we have very well constructed regimes, but the overall outcome is nonsensical. What is true of the parts, logic tells us, is not necessarily true of the whole, or vice versa. Ice cream is good, and cucumber salad might be good, but certainly ice cream plus cucumber salad is not good. Out of this experience, of course, out of this logical problem, politics has developed all types of different theories of checks and balances, of setting ambition against ambition, of different spheres of justice, which follow different types of logic, which cannot be universalized. Second, the argument from experience. Let me just mention three. First, the discussion in international law about the embarrassment of riches, the existence of freestanding regimes, which are defined as regimes in issue areas who not only have primary rules for how to behave, but also secondary rules which decide or allow you to decide whether the primary rules have been followed. Here, WTO, with its dispute resolution mechanism, is a perfect example of such a freestanding regime. And then the question arises, well, to what extent does then the WTO have to take into account other regimes, like human rights, environment? And then the question arises, how do then all these well-constructed regimes again relate to each other? So, too much of a good thing do we seem to have, because the international lawyers, and particularly two presidents of the International Court of Justice, considered this a serious problem for the evolving international legal order. So, why is it so? Two things are left out, as I said: interaction effects among the regimes and issues, so not only normative problems, but how issues get bundled, how social consensus emerges, for example, to treat the oceans as a unit, while formerly it was disaggregated in 3 or 4 or 6 different regimes, depending on how you count them. All of that does not come naturally. It's part of political processes. Secondly, there is no attention or given to the problem who makes then the decision of what the issue is and what type of norms should be applied. Let me give you a second example. Famous case which pitted Ireland against Great Britain and led to a row in the European Union. England, the UK, built a nuclear processing plant, reprocessing plant in Sellafield near the Irish Sea. The Irish objected to this because of the not apparent but potential danger that might, a nuclear accident might foul the sea, and since they were only about 50 miles away, that might impact on their interests. So after they didn't get any redress from Great Britain in that respect, they instituted 3 suits in 3 different courts. One with the Law of the Sea panel in Hamburg, under the Law of the Sea Treaty. The second one in a panel of a environmental regime protecting the North Atlantic. And the third one within the EU. Now the struggle of who has, so to speak, the hegemonic claim, who is supposed to decide that question. Because the EU, the court of the EU, of course, immediately jumped the gun and excoriated the Irish, that this was, after all, a community issue, and it should be only treated in community thing. But international law gives you the freedom of choice, and it falls under the two other regimes as well. So that raises the more general problem of who decides what the hegemonic discourse is. And it also shows you that what formerly was a struggle between states of who defines the terms of discourse has become a struggle between functional regimes. So, contrary to the benign argument that functionalism is the solution, it might be the problem. As we find out in the recent developments, is it a good idea to leave to the bankers to decide on reserve requirements? Who elected the bankers? Why should we trust their expertise when obviously they did not foresee or didn't take the right measures to stem the ongoing crisis? But before we are hitting only the bankers, we have also to see there has been a long, long process in which profits have been in general privatized and risks have been socialized. It started in the Italian Renaissance and with the Bank of England, in which the national debt for carrying out wars was financed. And money was raised not only domestically but also internationally for that purpose. As a matter of fact, Kant, in one of his articles on perpetual peace, warns that foreign debts which are contracted by sovereigns to make war should be forbidden. The second experiential example is UN peacekeeping. In virtually all of the recent operations, which are highly complex operations, we apply models which were tried out in quite different circumstances. Peacekeeping worked in the Middle East. It already broke down in the Congo operation. And nowadays, we are supposed to not only keep the peace or build a peace, we are supposed to provide reconciliation and human rights, as if all of them came like hand in glove. What we usually don't want to do, or are too lazy to do, is to ask, first of all, what is the right question? Not what is the right answer. We have the right answer, and the right answer of intervening and interjecting people into this, peacekeepers into that particular conflict, is then looking, so to speak, for cases to apply, right? That in organizational theory has been called the garbage can model of organization. You have solutions, and you look where to apply it, and basically the solutions are really not solutions because they're not tailor-made to the recognition of the problem, but they're like a garbage can in which you dump whatever when you walk by. Another example along the same line is, of course, the whole problem of humanitarianism. Humanitarianism is not a natural thing. It has been fought for and was by fortuitous circumstances adopted by the European powers in the 19th century on the basis of the work of one man, actually, and some of his helpers, Henri Dunant, who convinced European powers that people on the battlefield, when they are down and they are dying, or could be saved still, are no longer good to any one of the belligerents, and therefore to assist them and to give them medical help would be a good thing to do. It was a totally apolitical and decidedly so apolitical argument, and it was solely based, and he convinced the people, precisely because he could maintain under such circumstances, by not taking part of who is right in the war, who is wrong in the war, should we punish the aggressor, should we... He was right in that only in that way he could carve out this area which then the Red Cross took over. Now the problem of humanitarian intervention, when you look nowadays to it, is something entirely different. We are not only supposed to save lives, which would be nice, but we are supposed to save lives not under those circumstances. We are supposed to save lives under civil war conditions. And how you can become neutral under such conditions is a tall order to do. It cannot be done. So that is also, humanitarian arguments have been mushrooming. They are no longer supposed to be limited to assisting in very special circumstances to the battlefield soldiers or to prisoners of war, which the IRC is also supervising. But it is a solution, a universal hammer now for all types of solution, including bringing equality to all people, democracy, regime change, free trade, what have you. Let me now go to the three cases which serve as my prism. First, the discussion about global collective goods. Here, usually, the Hardin's tragedy of the commons is quoted, and it's pressed into a framework of a highly economistic understanding of public goods. Public goods, if you remember, are in an economist understanding, not a bonum, not a good related to the common weal. But goods are traded like commodities, and these goods are public because they are non-exclusive. You cannot exclude the people from using them, and they are non-rivalrous in consumption. So the basic background is, of course, the goods supplied by the market, which are private, which are rivalrous in consumption, and excludable, right? So the problem with this conceptualization then is right off the bat that not only do we have a narrowing down of the understanding of what is a good, the old bonum argument, which then becomes a task for the state, which it has to supply. For example, if you look at Adam Smith in his Wealth of Nations, he makes the first argument that education is a public good. But it's certainly not a public good in the economistic sense, and especially for Smith, because at that time, all the education was private in England. So obviously it meant something different. Secondly, we have also found that, of course, there are hardly any public goods. There are club goods, a lot of them. That means you can exclude people. You can exclude them in national security by not defending them, not having an alliance. There might be sometimes rivalrous, there might be subject to crowding. Many of the so-called public goods, as we all know, like air, which is usually given, is not a public good, because otherwise you couldn't have a pollution market, right? Secondly, I mean, how much of which good is supplied under what circumstances needs a decision. Again, public goods come not simply as parcels like this, right? How much clean water do I want as opposed to increase agricultural production? How much preservation of nature shall there be as opposed to having zoning laws allowing for high rises, etc.? And that then presupposes a decision-making body, usually justified in democratic theory, that all the citizens, through their representative actions, have to decide these questions. And it is clear in whose name this decision was taken. That means before you can decide on a public good, you have to decide of who the public is. That is the crucial part in the public goods debate, not whether they can be allocated exclusively or whether they are rivalrous in consumption. And here is what we immediately encounter the problem. If we look, for example, at the argument that you could now use all these nice little sites where new regulations are made, like in the WTO, etc., as long as the stakeholders get assembled and give their input. So the argument is usually for greater transparency. So what you have is that the World Bank puts things on the website. Even the IMF does that now. NGO persons can read it. They even get a coffee every now and then, are marched into the room in order to be given the agenda of what will be on the agenda, which of course, as soon as it is then discussed, they are marched out of the room. And that's about it. Right? So to what extent that is participation or accountability, I really would like to know. Despite also the fact that, I mean, it's notoriously difficult to identify the stakeholders. Anybody who has ever dealt with administrative laws and the objections to this type of model in American law will know about that. The second issue is that the deliberations, even if people are allowed to discuss things, the deliberations are very much constrained. They are constrained to the vested interests which are on the table. And secondly, in the WTO, they are constricted to trade issues, for example. They are not going to discuss environmental issues or human rights issues. And that's even if you have accountability through court review or so on, the court is also not able to institutionalize such a discussion across regimes. Let me finally go, so that was about regulation. The third issue I want to raise is the argument that all we need is more human rights, right? And human rights is supposed to be now the Deus ex machina, which will solve our problems. The first problem is, of course, that whether something is right or whether you have a right are two different things. And people are usually not quite clear about that, because having a right means that you can do the wrong thing. That's the whole point. But nowadays, the human rights discourse constantly meanders between these two different meanings of right. It is right that versus having a right. And then, of course, human rights proliferate because depending on whether you move from having a right, which originally defined you, for example, as an actor. So in your natural liberty, you have certain basic human rights. But if you look at the list of human rights nowadays, I mean, the newest one I could come across is now the right to internet access. Well, it would be nice to have that. But considering that 2/3 of the people in this world go hungry to bed, I doubt very much whether that is a human right. And that should be one of our priorities. So the usual argument to this criticism there is that all human rights are mutually supportive and of the same quality. This is remarkably stupid, even if one of the human rights persons of the UN has maintained it several times. There might be all rights, even if I assume they are all rights. Fine, let's for argument's sake. Some of them might be bigger or more important than others, right? Numbers qua numbers are all the same. Rights qua rights might be all the same. But it doesn't mean that all numbers are equal. It doesn't mean that all rights are equal. There are elemental logical mistakes in these arguments. It might also finally get us out of this question that, discussing rights without having any type of attention paid to the question of not only who can claim them, but also who has the corresponding obligation. It's very well to say that it would be nice that each one had enough to eat. I can agree to that any time. That is not difficult. Right? I might even be agreeing to that it should become a type of manifesto right that puts international organizations and states, the international community as a whole, under obligation to do something about that by saying it is a human right. But without specifying against whom it can be claimed, against humanity, that and $1.50 gets you on the subway every time, right? It's useless to make these types of arguments. This is why we have institutions. And unless they are assigned, the duties are assigned, the rights talk is not really going to help us very much. It might also be entitling us to say that there are differential obligations. Not only are rights different among each other, but also that obligations should fall differently on that. We have that in domestic orders all the time. For example, if you see a fire, of course you would have an obligation to help, but you're not going to run and help put out the fire. There's a fire brigade here. And you say, that's their job. Well, if you hear somebody who is screaming or so on, you might be inclined to say, well, now it's on me, and I have to do something about that. But usually, that's exactly why we have institutional obligations. And without institutions, we cannot intelligibly discuss this question. This leads me to the argument that really rights talk is highly problematic. There cannot be, for example, as Dworkin once said, a right, an individual right, to drive downtown on Lexington Avenue, because Lexington Avenue is the other way around. This falls under the police power of the state, and the state has to make certain regulation, and it cannot be conceptualized as an individual right. Right? Similarly, also the smoking ban. I mean, there are good reasons to have non-smoking rooms in restaurants or in hospitals and so on. But it cannot be conceptualized as an individual right. Because what about the rights of smokers? Well, now we have forgotten about that. Free choice or so on shall not matter at all. If this is a type of sectarian argument, if you know what is right, you don't have to worry about the rights of others. So ultimately, political decisions have to be made, and the question of the adequate political discourse has to be raised. And we must recognize that political questions have these unenviable characteristics, that they concern problems which have no logically compelling solutions. You need not be an adherent of rational choice, but Arrow's theorem, for which he got the Nobel Prize, tells you clearly that if you have more than three people, he makes the argument, with independent preference orderings which are not the same, you cannot find a logical way of uniting them to a joint one. And secondly, the problem is even more difficult. It's not a logical one, it's the practical one. You have to arrive at binding decisions. You cannot leave it to the individual's choices. So the idea of private ordering and everything which enhances private choices is like, the world as a shop. Everything seems to be like a consumer's choice. It isn't. Politics isn't like that. So what that means is that the questions of whether there are really chances to democratize or hold more accountable the existing lawmaking bodies and thereby improve upon, not only in terms of knowledge or so on, but in terms of accountability, the emerging regimes, I'm a bit skeptical. Why? The argument that you can have surrogate political arenas in which, for example, members of NGOs who are part of civil society will represent you, I hold it for a very suspicious argument. Not only for the simple reason that if you go to the internet and you look of what is all going around there, you will find that a lot of them are rather uncivil. That's the first thing. The second one is that they also share the defect of functionalism. They're all one-issue organizations. And for good reasons. I mean, Amnesty International is not going to worry about world hunger. And the lovers of whales or whatever are not going to worry about prisoners of war. Right? So again, they don't have these type of necessary variety of concerns which is crucial for political decisions. Well, what about then other possibilities, not in the functional area, but in the area, let's say, e-democracy? We have for the first time the possibility, as Luhmann so nicely says, everybody can nowadays virtually reach everybody else. That might be exaggerated. I mean, the fact that Manhattan has more telephones than all of sub-Saharan Africa tells you that globalization is very uneven. So that might be also myopia. But let's assume that with cell phones and with all types of things, that will improve. And we are also constantly now being told we can vote. You know, you click on BBC and said, are you for it? Are you against it? I mean, it's like, you know, should we do this? Should we do that? Well, this is registering private preferences. This is not a deliberation. For a deliberation, and studies on internet democracy also show another very disturbing trend, which is that, first of all, these discussions have no seriousness because people check in and out. They are not like a decision which has to be made whose consequences you have to bear. Right? Secondly, as we all see, they all show the marked tendency to radicalization. Apparently people don't like of being around other people who have different ideas. So they rather set up their own chat room, which only the true believers are assembled. And then that chat room will splinter again. Again, the issue of sectarianism arises here. So what we have here is that these deliberative processes lack two important elements which are necessary for democratic legitimacy. First, all-purpose competence to decide. Secondly, the seriousness by which you commit yourself, and then as an outcome, naturally, that you are not relying only, I mean, on the mechanism of exit, but of loyalty, right? And how these types of new mechanisms could instill something like that. After all, I mean, Exit Voice Loyalty was a famous book by Hirschman about 30 years ago, in which he tried to show that societies have to have all three of them in order to function. You cannot just make one of them as the, not even as the primary means of choice. So what is the result to which I come is not only that politics matters, but also that states do matter. And not only in the bad sense that they are the ones who naturally also have to enforce all of these things, and they are the ones which might put you in jail if you go against that, but also the good side, because without them, there could not even possibly be any type of regulation. And it is a cautionary tale also about the dangers of universalization, of trying to drive out diversity and not allow for diversity, which is exactly the best practices argument. Everything has to be exactly the same because it has to be comparable, right? We have a big discussion in Europe, and not only for political reasons, also for legal reasons. You know, societies make different choices, even if you are you know, giving everybody a fair hearing, or you say that he has to be provided by reasons when a court makes a decision or so on. As soon as you go in the different tradition, you will see it leads to entirely different sets of rules. In Great Britain, you have powerful judicial review, but, for example, the rights of contesting administrative agencies' decisions so can be ousted by Parliament, right? In Germany, you have also access to courts and judicial review. In Scandinavia, nearly never, but you have a settlement by an ombudsman, but you are given reasons and you are given information. In England, until the Freedom of Information Act and various restrictions, you don't get information. The government need not tell you on what basis they have made the decisions. The EU has now adopted a type of different thing. So what we see here is different legal systems develop differently. They are part of historical choices which are made, and they are, of course, in dialogue. But it is a good thing to have a diversity, because even if you believe in evolution, whether that evolutionary metaphor is very helpful for social things, I have my doubts, but let's assume you are in evolution. Then you have to have the requisite variety, or evolution will not take place. And that is the dark side of global governance. Thank you.